Juan Mojico Crecido, who I understand needs a Spanish interpreter.
Good morning, Your Honor. This is Alan Figueroa, State Certified Spanish Code Interpreter, already sworn.
Great. Thank you, sir. All right, Mr. Crecido, I'm going to appoint the public defender standing next to you to serve as your attorney. Do you understand? Mr. Crecido, do you understand me? Yeah? I'm appointing the public defender to serve as your attorney, okay? All right, I do find probable cause in this case. I understand there's a prior bond. I'm inclined not to revoke the prior bond. I'm inclined to set bond at $1,000 on count 1 and $2,500 on count 2 in this case with no contact with the victim. Anything from the state?
I'm sorry, Your Honor, can you please repeat the bond for count 2?
$2,500.
And, Your Honor, this time the state would be asking for no contact and to maintain separate residences?
Yes, I'm inclined to $1,000 on count 1, $2,500 on count 2, no contact with the victim, separate residences. I'm not going to revoke the prior bond unless there's anything else further from the state.
No, Your Honor.
Anything from defense?
Yeah, I'm Mary Abraham on behalf of the Public Defender's Office. Your Honor, we would just be asking for a one-time assist so my client can retrieve his belongings from the home with law
Granted.
enforcement officer.
One-time assist with law enforcement to retrieve belongings from the home. Sir, do you understand?
Yes.
You're going to receive a bond, but you cannot have any contact with the alleged victim. That means no communications, you can't go see her, no text messages, no nothing. You are going to be able to go back to the residence one time with law enforcement. Your attorney can help you arrange that to retrieve any personal belongings, okay?
Yes.
Do you understand everything, sir?
Yes.
Okay, have a nice afternoon, sir. Okay.
We only have one Spanish.
Yeah, that was the only Spanish. Next, we have a Portuguese.
I have them on the line. I'm just waiting on you to
Okay. Mr. Interpreter, thank you very much for your service today.
Not a problem, Your Honor. Is that everything for Orange and Osceola counties?
Do we have any, can we check if we have any witnesses that need a Spanish interpreter?
I can ask, Your Honor. Las personas que están en el público, ¿hay alguien que necesita el intérprete de español? Levanta la mano, por favor.
I can see, I think the staff member's waving no, is that correct? Okay. All right, thank you, Mr. Interpreter. We're all done. Have a great day. Okay. So did we figure out there's some way on the language line for you to speak privately without us having to do the other phone? Is that what we figured out yesterday?
It was just the same way we
Okay.
did it yesterday.
Officer Deputy, I remember you came up and said something about figuring out how to use the headphones for them to talk. Was that, did we figure that out?
We need another set of headphones. We don't have
Alô, eu serei a sua intérprete de português.
Okay. Okay, Ms. Lopes? Okay. You speak Portuguese, correct? Okay.
Senhora Lopes, a senhora fala português, correto?
Sim.
How much English do you speak?
É. Quanto inglês a senhora fala?
Eu mais entendo do que falo, tipo uns 20%.
I understand more than I speak, about 20%.
Okay. I'm going to appoint the attorney sitting next to you, or standing next to you, as the public defender, and I'm going to appoint her to serve as your attorney.
Ok, a advogada que está ao seu lado é uma defensora pública. Eu vou nomear ela para servir como sua advogada.
I'm going to tell you what I'm inclined to do in your case.
Eu vou dizer para a senhora o que eu estou querendo fazer no caso da senhora.
You have a right to speak privately with your attorney.
A senhora tem o direito de falar em particular com seu advogado.
And if you would like to do that, let us know, and we'll have to set up another phone line for you, but we could definitely do that if you'd like to have a conversation privately with your attorney, okay?
Se a senhora quiser fazer isso, avisa pra gente. A gente teria que fazer outra linha telefônica para isso, mas me avise se a senhora quiser ter uma conversa em particular com a sua advogada, ok?
And counsel, same to you. If you want to talk, whether she wants it or not, we will set it up. Just let me know.
Thank you, Your Honor.
E mesma coisa, a senhora advogada. Se quiser falar com ela, a gente pode organizar isso. Só me avise.
Okay. I do find probable cause in your case, ma'am, for battery domestic violence.
Eu estou encontrando causa provável, no caso da senhora, para agressão e violência doméstica.
I'm inclined to set bond at $1,500.
Eu estou querendo fazer uma fiança de $1.500.
With no contact with the victim and separate residences and no return to the scene.
Incluindo que não deve haver contato com a vítima, deve haver residências separadas e não pode haver retorno à cena.
Anything from the state?
O Estado quer dizer alguma coisa?
Nothing from the state, Your Honor.
Ma'am, did you understand what I said?
A senhora compreendeu o que eu disse?
Sim.
Would you like us to arrange an interpreter for you to speak privately with your attorney?
A senhora quer que nós chamemos um intérprete para a senhora falar em particular com a sua advogada?
Acho que não é necessário. Eu só quero entender essa fiança que eu tenho que pagar, como eu vou fazer para pagar, porque eu não tenho como pagar essa fiança hoje. Não sei como que eu vou fazer.
No, I don't think it's necessary. I'd just like to know how I can pay bail because I can't pay today.
Some of the logistical questions will be answered downstairs. If you would like to speak to your attorney now, I can arrange it. It'll take a few minutes, but I can arrange an interpreter, and I'm happy to do that if you'd like to speak privately with your attorney. You have a right to do that.
Algumas das perguntas logísticas vão ser respondidas lá embaixo, mas se a senhora quiser falar com a sua advogada em particular, será um prazer fazer isso para a senhora. Eu tenho como arranjar outro intérprete.
Ok.
Would you like to speak with your attorney?
A senhora vai querer falar com a sua advogada?
Sim.
Okay. What we did
Yeah.
yesterday that seemed to work is we just called a second interpreter on that phone because she has to be able to speak privately with her attorney. And I know that this one, once we have over the loudspeaker, can only operate over the loudspeaker. So the same number that we used to call that interpreter, can we just call a second one on that phone?
Ontem nós chamamos outro
Yeah,
intérprete.
I'm ordering you to do it, so definitely do it.
Yeah, just give me 1 second, 'cause
Okay, thank you
Your
very much.
Honor,
Take your time.
If I may, just while we have the other interpreter on the line, can we order a one-time assist with law enforcement officer for her belongings?
Yes.
And does the question also be, does she not qualify for direct PTR?
She did not.
Yeah, I don't have her qualifying for direct PTR.
Então, podemos pedir uma assistência, enquanto nós temos a intérprete no telefone, uma assistência única para a remoção dos pertences da senhora, já que a senhora não é elegível para o PTR.
Okay.
The last request to Your Honor would just be if we could lower the bond to $500. It seems to be that might be a little bit more affordable.
O último pedido, meritíssimo, se podemos baixar a fiança para $500. Parece que isso seria mais dentro da possibilidade dela.
State?
Your Honor, I would just leave it in this court's discretion.
Okay, all right, I'll set the bond at $500. No contact with the victim.
Ok, então eu vou deixar a fiança em $500, não pode ter contato com a vítima,
Separate residences
residências separadas,
and one-time return to the scene to retrieve belongings.
Retorno só para a cena para buscar os pertences.
so you taking off the no return,
No return, except one time with law enforcement.
so you want the no return and
Não
the
pode
maintain.
retornar,
Correct.
só uma vez com os
Right.
policiais.
Okay, while we do that, why don't we go ahead and get the interpreter set up? And that way you can be working on the order.
We're gonna try the headsets.
Oh, great. Madam Interpreter, just stick with us. We're trying to figure out a way for, right now you're on a loudspeaker, I'm not sure if you know, but we're trying to figure out a way for you to be on a smaller system where two people can talk privately. So if you would, just please stand by for just a minute.
Yes, Your Honor.
You all just let me know if it's working, okay? Because I probably don't want to hear, so just give me a thumbs up or something.
This one?
Yeah.
Thank you, Madam Clerk.
Well, okay, this is Mary Clark from the Public Defender's Office. I'm just going to ask if you can translate some of the questions.
Madam Interpreter, just stay with us.
Yes, Your Honor.
She can hear through that? So she needs to. Give me one moment, sorry.
Well, it worked yesterday. Okay, ma'am, did you have a chance to speak with your attorney? Okay, do you understand what we're doing today? Okay, it's gonna be a $500 bond, no contact with the victim, separate residences, no return to the scene except a one-time return to collect personal belongings. Madam, translator, can you translate that for us?
Então, a senhora entende, a senhora falou com a sua advogada, então a senhora tem a fiança de $500, tem que ficar longe da vítima, não pode voltar à residência, só volta uma vez para buscar os seus pertences.
Thank you.
And Your Honor, just for the record, she does have a son involved, and she would just like a mutual party to be able to have contact with him, agreed upon by both.
Any objection from the state?
Oh, I'm sorry, I was waiting for the interpreter. No objection from the state.
Go ahead, Madam Interpreter.
Meritíssimo. Meritíssimo. Tem mais uma questão, ela tem um filho envolvido e ela gostaria de ter uma mediação para poder ter contato com o filho. Alguma objeção do Estado? Nenhuma objeção do Estado.
Okay, she may have the contact with the children through a neutral third party.
Thank you, Your Honor.
Ok, ela pode ter contato com as crianças através de um terceiro de contato mútuo.
Good luck to you, ma'am. Have a wonderful day.
Boa sorte para a senhora, tenha um dia maravilhoso.
Obrigada.
Madam Interpreter, that's all for today. Thank you very much for your help.
You're very welcome. If that's all for the interpreter, thank you for your
Yes, ma'am, thank you. Okay, we have Mr. Bettencourt Bocanegra.
Yes, sir. Your Honor.
Okay, Mr. Bettencourt Bocanegra, I'm going to appoint the public defender standing next to you to serve as your attorney. I see we have a prior bond in this case. I do find probable cause. I'm inclined to set the bond at $2,500 on count one, $2,500 on count two. No contact with the victim, separate residences, no return to the scene,
Your
no
Honor,
drugs
if I
or
may.
alcohol, and I am inclined to revoke the prior bond. Anything from the state?
Nothing from the state, Your Honor.
Anything from the public defender?
Yes, Your Honor. The defense is going to argue the charged battery on a person of 65. There is nothing in the four corners of the affidavit that identifies how old this alleged victim is. So we would be arguing the PC on that specific charge.
Let me look. State defense counsel appears to be correct. There is nothing identifying the age of the victim.
So, Your Honor, the state would make two arguments. The first one is that there is a witness form attached to the affidavit, which does indicate the victim's age as 87 years old. Alternatively, pursuant to Florida Rule of Criminal Procedure 3.133, the state has a 48-hour period from the time of the defendant's arrest.
Well, there's another charge, so he's going to have a bond either way. And I'm also revoking the prior bond either way. So he's not getting out today. But I don't think I can rely on the witness form because it's not sworn. Is it?
Okay, Your Honor. I was just gonna ask for a 24-hour reset for the state to be able to provide supplemental information regarding, that, like, the first count. However, if the conditions will remain the same,
No, I'll give you the reset if you want. I'm saying, do you still want the reset knowing he's not going to get out today?
No, it's okay, Your Honor. We'll move forward.
Okay. I am revoking, I'm going to set the bond at $2,500 on count two. No PC on count one. No contact with the victim. Separate residences, no return to the scene, no drugs or alcohol. I am revoking the prior bond.
And he does have another case, Your Honor, another new offense.
Another new offense.
It's a violation of a domestic violence injunction.
Okay. Any probable cause argument on the Domestic Violence Injunction Council?
One moment, Your Honor. No argument, Your Honor.
Okay, I'm inclined to set bond at $2,500 on the violation of domestic injunction charge. Anything from the state?
Nothing further from the state, Your Honor.
Anything from defense counsel?
Just a one-time assist if he resides there. Yes, Your Honor, just a one-time assist with law enforcement officer.
One-time assist granted. So it's, let me see here. On the battery of a person 65 years or older, count one in that case, no PC. Count two, $2,500 bond. Violation of probation, the violation of domestic violence injunctions is $2,500 bond. And it's going to be no contact, separate residences, no return except a one-time with law enforcement, no drugs or alcohol, and the prior bond is revoked.
Do you want those same conditions in the injunction case as well?
Yes.
And then also on the battery case, since you found no PC for count one, do you want to ROR that count?
Yes. Count one, the one with no PC, battery for person 65 years or older is ROR'd. Anything else?
Nothing further, Your Honor.
Okay, Elantra Clay.
Your Honor, Ms. Calais had signed the form to waive the readings.
Okay, great. I do find probable cause.
Oh, I apologize, Judge, and we do have a PC argument for this as well.
Okay, let's hear it.
Defense would be arguing that my client was invited into this home and it shouldn't constitute as a burglary under the statute. She remained in the home, however, she didn't enter the home with an intention to commit an offense. She was already at this house for Christmas, so we would be arguing the burglary charge.
I mean, my understanding of the burglary statute is that if you remain after you're asked to leave, that it's enter or remain.
Yes, however, Your Honor, it also states that they have to have entered the home with an intention to commit a crime. I don't believe she entered this home to commit a crime. If anything, it would be at this point a trespass because she remained in a place that she was invited to.
State?
Your Honor, pursuant to Florida Rule of Criminal Procedure 3.133, subsection 3, the judge just needs to decide if there is probable cause within the four corners of the affidavit. The state does believe that a crime was committed here, either a trespass or a battery, a domestic violence related because of
Well,
the relation.
the affidavit is only burglary of a dwelling with assisted with, with assault and battery. So we're not going to do charges not in the affidavit. So give me the response to the probable cause affidavit, probable cause argument on the charge that's actually charged.
I'm sorry, Your Honor, just to clarify, what my argument is to you is that you're not limited by the charge and that's listed on the charging affidavit. That so long as you find that there is probable cause that a crime has been committed, you can find that probable cause of another crime has been committed.
Defense, is that correct?
I'm unaware of that at this time, Your Honor. We would just be arguing the four corners of the affidavit is what it is at this time. And they're accusing her of a crime that doesn't match the burglary statute 810.02 at this time.
Let me look at the language of the statute.
I'm sorry, Your Honor. The statute, just to quote, upon presentation of proof, the judge shall determine whether there is probable cause for detaining the arrested person pending further proceedings. The defendant need not be present. In determining probable cause to detain the defendant, the judge shall apply the standard for issuance of an arrest warrant, and the finding may be based on sworn complaint, affidavit, deposition under oath, or if necessary, testimony under oath properly recorded. There's nothing in that statute that says that Your Honor is limited to the charge that the officer believed was committed. I'm arguing that based on the facts in the arrest affidavit, at the minimum, a trespass because Ms. Calais was asked to leave, or alternatively a battery because there is testimony from the victim that an altercation did ensue, that there is probable cause for those charges, and therefore we can move forward in setting bail for a different charge.
So I'm looking at the burglary statute, and it says notwithstanding a licensed or invited entry, remaining in a dwelling, structure, or conveyance after permission has been withdrawn with intent to commit an offense. So if you're remaining with an intent to commit an offense, that's burglary. You don't have to enter with the intent to commit an offense. Defense?
And, Your Honor, we would be still arguing that she didn't have the intentions to commit an offense at this home. And if I give one moment just to read over the statute.
I mean, she committed the offense, so, or the affidavit established at least the affidavit establishes she committed the offense.
Yeah, the defense would just still be arguing that it would be a lesser included of a trespass as she was invited into this home.
All right. I'm going to find probable cause of this case. I'm going to set bond at, I'm inclined to set bond at $5,000 with no contact and no return to the scene. Anything further from the state?
Nothing further, Your Honor.
Anything further from defense?
One moment, Your Honor. My client's children reside with the alleged victim in this case, and there's a sister that could be a mutual party for them, so she can at least have access to her children, and she would also like a one-time assist with law enforcement officer. I don't recall if you stated that or not.
I did. Any objection from the state on the neutral using the sister to contact the children?
Oh, no objection to you, to a third party to contact the children, Your Honor.
Okay. Bond is set at $5,000, no contact with the victim, no return to the scene except a one-time with law enforcement to retrieve belongings, and she may use a third party to obtain her, to communicate with her children.
And I apologize, Your Honor. Last request was if the court would be inclined to reduce the bond so something more affordable to my client.
Any objection from the state?
No, Your Honor, I would leave it in Your Honor's discretion.
Okay. I'll set the bond at $2,500, counsel.
Thank you, Your Honor. And I apologize, the Public Defender's Office is appointed in this case?
Yes. Oh, sorry, yes. Public defender is appointed. Okay, ma'am, you have a wonderful afternoon. Good luck to you. Amos Foster.
Yes, sir.
Okay, Mr. Foster, I'm going to appoint the public defender standing next to you to serve as your attorney. I do find probable cause in this case. I'm inclined to set the bond at $2,500 on count one and $2,500 on count two with no contact and separate residences. Anything from the state?
Your Honor, the state would also be asking, due to the charges, for no weapons or firearms.
Anything from defense?
Nothing further, Your Honor.
Okay, bond is set at $2,500 on count one, $2,500 on count two, no contact from the victim, separate residences, and no firearms or weapons. Sir, if you possess any firearms or weapons, you're going to need to surrender those within 24 hours, and you're, pardon? All right, you don't have to go into that now. I'm just saying, if you have any, you have 24 hours to surrender them. If you don't surrender them in the 24 hours, you'll be in violations of your conditions of release. Do you understand?
Okay.
Okay. Good luck to you, sir.
I'm sorry, Your Honor, to clarify, is there a one-time return with law enforcement?
Was there a need for a one-time return? I didn't think they were living together anymore. Yeah, no, no one-time return.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, Cressida Juan Mojico? Am I stating your name correct, sir?
Married.
Ah, okay, sorry. Joseph Nguyen?
Sir.
Okay, sir. Sir, I'm going to appoint the public defender standing next to you as your attorney. I see there's a prior bond in this case. I am inclined to, I do find probable cause. I'm inclined to issue a bond of $2,500 on count one, $1,000 on count two. No contact with the victim, no return to the scene, no drugs or alcohol, and I am inclined to revoke the prior bond.
Your Honor, he's not out on bond on anything. He has 3 separate cases today, but
Oh, I
he's
mixed that
not
up.
out on bond.
Okay, I may be
And there's a-
mistaken. Hold on here.
He's here, yeah, here on 3 separate cases today.
Was there not another issue with with him? State, am I incorrect?
I'm sorry, Your Honor. What my records show is that there's one case with false imprisonment, criminal mischief, 1 case with battery, dating violence, and 1 violation of probation.
No prior cases?
No, sir.
I'm sorry, Your Honor. I'm not seeing that information.
Okay, all right. So I'm inclined for $2,500 on the false imprisonment, $1,000 on criminal mischief. Okay, all right. On the battery with domestic violence, $2,500. On the violation of probation, $2,500. And good afternoon, ma'am. Would you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you, while you're in there, can you take the mask off so we hear you? Yes?
Yes.
Ma'am, if Mr. Nguyen gets out, do you want contact with him?
No.
No?
No.
Okay. I'm inclined to order no contact. Anything from the state?
Yes, Your Honor. I'm sorry, were drugs or alcohol involved in this incident?
No.
And,
Defense would object to that question as well, Your Honor.
Why?
Relevance. If it was involved in the incident, it would have been indicated in the report.
Overruled.
thank you. No further questions from the state.
Defense?
One moment, Your Honor. Nothing further, Your Honor.
Okay, bond is set at $2,500 on false imprisonment, $1,000 on criminal mischief, with the conditions of no contact with the victim, no return to the scene.
And you said, do you want to strike the no drugs, alcohol? You ordered that too.
I'm going to order the no drugs and alcohol, actually. On the battery charge is $2,500, same conditions. And on the violation of probation is $2,500, same conditions.
So you said in bond in that Lake County, the 2,500, right?
Yes. Sir, good luck to you. All right, Tyrone Thompson.
Sir.
Are you Mr. Thompson?
Sir.
Good afternoon, Mr. Thompson. I'm going to appoint the public defender here as your attorney. Is there a probable cause argument on this one?
One moment, Your Honor.
Okay. I don't think there's probable cause in this case. Taking a cell phone from somebody is not an aggravated assault. It's not an aggravated battery. There's no indication he touched her body to touch the cell phone.
Your Honor, at this time, the state would ask for a 24-hour reset.
And Your Honor, defense would object to a 24-hour reset. The officer had ample time to be able to make his report adequate for court and to hold my client another day in jail. Defense would be objecting to that.
Your Honor, pursuant to Florida Rule of Criminal Procedure 3.133, the state has 48 hours to establish probable cause. The state does so at 24 hours out of convenience. because the initial appearance has to happen within 24 hours?
I'm going to grant the 24 hours. Ma'am, thank you for coming. There's going to be another hearing within 24 hours. And at that point, they'll discuss whether Mr. Thompson's going to get bond or not. And at that time, they'll want to hear from you as to your thoughts on this case, okay? He's not getting out today.
So would I have to come back tomorrow?
You will have to come back if you'd like to speak about whether or not you want contact with him tomorrow.
Okay.
The judge tomorrow is going to decide whether he gets out.
And what time will that be?
It will be at the same time as today. I think it'll start at 11. No?
No, it'll.
It's gonna be 9.
It's gonna be
9 a.m. I stand corrected. Thank you, Madam Clerk. 9 a.m. tomorrow.
Okay.
Same place.
All right, thank you.
All right, ma'am. You have a wonderful day. All right. Nicholas Castell?
Yes, sir.
All right, Mr. Castell, I'm going to appoint the public defender to serve as your attorney. I do find probable cause in this case. I see he's eligible for PTR. I'm inclined to grant the PTR with the conditions of no contact and no separate residences from the victim. Anything from the state?
Nothing from the state, Your Honor.
Anything from defense?
One moment, Your Honor.
Take your time.
Sorry, and you straight PTR, correct? Yeah. Or Mark Dial? This one that you found.
Yeah, we haven't done Mark Dowd. This is Nicholas Castell.
I'll write it down, thank you.
Are we missing his form, his order? Do we know that the one before this was correct? Yeah. Thank you, Madam Clerk.
Your Honor, just a one-time assist. I believe he's got belongings at her residence.
That's fine. There'll be a one-time assist with law enforcement to retrieve belongings. So it's PTR, no contact with the victim, separate residences. No contact, sir, means no contact, no text messages, no emails, no phone calls, or else you'll be in violations of your conditions release, and you'll be back here without release. Do you understand?
Yes, sir.
Okay, you can go back one time with a law enforcement officer to retrieve your belongings. Your attorney can help you arrange that. All right, sir, good luck to you. Yes. Thank you very much, Madam Clerk. Mark Dial? Mr. Dial, I'm going to appoint the public defender standing next to you to serve as your attorney, okay? I do find probable cause in this case. Looks like there's 2 prior cases. Is that correct?
That's correct, Your Honor. He's out on bond on 2 cases.
Okay. I am inclined to revoke the prior bonds. I'm inclined to set bond in this case at $2,500 on each charge with no contact with the victim and separate residences. Anything from the state?
Your Honor, also to abide by any injunctions in place.
Okay. Let's hear from the witness. Ma'am, would you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do.
He's not getting out today, but when he gets out, do you want contact with him?
No, sir.
Okay.
No hostile contact is what I had requested in the past.
Well, there's 2 things I can order. I can order no hostile contact, which means he can't be hostile with you, and I can order no contact, which means he can't contact you at all. Which would you like?
No hostile contact.
Okay. Anything from the state?
Your Honor, at this time, the state has no questions for the witness, but the state will be asking for no contact. The injunction in place actually stated no hostile contact. It was not abided by. Additionally,
I'm going to order no contact, counsel.
thank you, Your Honor.
Anything from defense?
Nothing for the Your Honor.
All right. The prior 2 bonds are revoked. Bond in this case is set at $2,500 per charge. No contact with the victim, separate residences, and no return to the scene. Sir, good luck to you.
Defense will just ask for one-time assist if necessary for his belongings.
One-time assist granted.
Thank you.
All right, Chandler Elmore Birch.
You ordered a abide by the injunction that the state wanted for his case as well? Or do you?
Mr. Elmore Birch, I'm going to appoint the public defender standing next to you to serve as your attorney, okay?
Yes, sir.
All right, I do find probable cause in this case. I see he qualifies for PTR. I'm inclined to do that. Anything from the state?
Yes, Your Honor, with the condition that he not drive until he has a valid license and no weapons or firearms.
Anything from defense?
Your Honor, is there a second case regarding driving?
There's a duelist as well as a violation of domestic injunction.
Okay, I only have the domestic injunctions.
I only have the domestic one.
Oh, I'm sorry.
He also has a driving while license suspended.
Ah, okay, yes.
We would just be asking for bond in that case then as well.
I mean, I'm inclined to give PTR in both cases.
Okay, thank you, Your Honor.
Okay, it's going to be a direct PTR. No contact with the victim. Comply with all domestic violence injunctions, and no firearms or weapons. Sir, do you understand the conditions?
Yes, sir.
No contact means no contact. That means not a phone call, not a text message, not an email. Any contact, and you're going to be in violation of your conditions of release, and you're going to be back here and have a much harder time getting released. Do you understand?
Yes, sir.
Okay.
And are there any conditions on the duelist case, Your Honor?
Same conditions. Conditions are on both cases.
So just a no contact and no weapons?
No contact, no weapons, and
Fine.
comply with all domestic violence injunctions.
Okay, I got that.
All right, Donta Robert Chandler.
Oh, actually,
Is that who we have next?
I don't have a,
Oh, I'm sorry, that was the last one. Never mind. Ms. Holloway's medical? Okay. Reschedule medical for tomorrow.
Your Honor, it looks like she's in medical due to respiratory precautions, just to kind of alleviate any more spread in the jail. I can waive her appearance and go forward, so she can be released once she's cleared.
Okay. I do find probable cause. I'm inclined to set the bond at $2,000. No contact with the victim. Anything from the state?
For clarification, Your Honor, the PDs were appointed to this case
Yes.
and just separate residences.
Okay. Anything from defense?
I haven't had an opportunity to speak to her, so just maybe a one-time assist if that's necessary for her situation.
Bond is set for Ms. Holloway at $2,000. No contact with the victim, separate residences, except for a one-time one-time return with law enforcement to retrieve belongings.
Thank you, Your Honor.
there appears to be a alleged victim in the booth.
That's for Tiana Holloway, right?
For Ms. Holloway?
Yes, I'm the victim.
Okay.
And yeah, I just,
Would you please raise your right hand?
Yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth to help you God?
yes, sir.
Do you want contact with Ms. Holloway if she gets out?
No, sir.
Okay. I'm ordering no contact. Anything from the state?
No, nothing from the state, Your Honor.
Defense?
Nothing from the defense, Your Honor.
Thank you, ma'am.
Thank you.
Brianna Jarrett? Okay, Ms. Jarrett, I'm going to appoint the public defender standing next to you to serve as your attorney, okay? I do find probable cause. I see she qualifies for PTR. I'm inclined to grant PTR with the conditions of, well, let's hear from the victim. Ma'am, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
If Ms. Jarrett gets out, do you want to have contact with her?
Yes.
Okay. Has this ever happened before?
No, Your Honor.
Okay. If something happens, will you call the police?
Yeah.
Okay. Anything from the state?
Do you believe that drugs or alcohol were a factor in this incident?
Objection, Your Honor, to relevance. I have to put that on the record.
Overruled. Go ahead.
Not at all.
Nothing further from the state, Your Honor.
I'm inclined to order no hostile contact. Anything from defense?
Nothing from defense, thank you.
All right. Direct PTR, no hostile contact. Ma'am, do you know what no hostile contact means? That means nothing physical. You can't even raise your voice. So if you so much as raise your voice to her, you're going to be in violations of your conditions of release, and you're going to be back here, okay? Okay, good luck to you.
Thank you, Your Honor.
All right, Maldonado Caraballo?
Yes, sir.
I don't think there's PC in this case. There was no threat.
Your Honor, yeah, defense was going to make a PC argument for this case as well.
Yeah, state, I don't see PC here.
Your Honor, the state at this time would request a 24-hour reset.
Okay, I'm
Your Honor.
inclined to grant the 24-hour reset, counsel.
For the record, defense will be objecting to that reset. It is a simple misdemeanor charge, and to hold him overnight again, defense would argue that that would not be just for him. The officer had ample time to write an adequate report, and at this time, state didn't meet their burden.
Your Honor, the state, to just rebut, would argue that the state is entitled to 48 hours to establish probable cause. The state does usually establish that within 24 hours out of convenience. However,
I'm going to grant the 24 hours.
Thank you, Your Honor.
I'm going to grant 24 hours. Sir, I'm finding there's no probable cause to hold you, but legally the state has 48 hours, so they've got another day to try to show a judge that you have probable cause to hold you or require a bond, okay? All right, sir. Good luck to you. You'll be back tomorrow.
No, in a second.
Gregory? Yes. Put them in the wrong order. Okay, Gregory Pelagios.
Good morning.
Good afternoon, Mr. Pelagios. I'm going to appoint the public defender standing next to you to serve as your attorney, okay? Okay.
Thank you.
I do find probable cause in this case. I see there's a prior bond. I am not inclined to revoke the bond. I'm inclined to set bond in this case at $2,500. Let's hear from the victim on contact. Would you,
I want contact.
you do want contact?
I don't even want
You
to.
don't want, all right, can you please raise your right hand?
Yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Do you want contact with him if he gets out?
Yes.
You do want contact?
Yes.
Okay, all right.
Yeah.
Anything from the state?
Yes, Your Honor. Has anything like this ever happened before? I'm sorry, can you answer out loud?
He was arrested for the same thing about a year ago.
Okay, and have you ever had to call 911 due to incidences similar to
No.
this?
Your Honor, objection to relevance. At this point, she wants no context. I think we've established what her
Yeah,
purpose
but
was.
her opinion is not dispositive, counsel. That's the issue. I haven't decided the issue yet.
Oh, I'm sorry, I thought she said she does want contact.
I do.
Oh, I thought she said no contact. I
Yeah.
apologize.
She wants contact. Go ahead, state.
I'm sorry, and do you believe that drugs or alcohol played a factor in this incident?
Objection. Relevance would have been in the report if it was an issue.
Overruled.
And if
Hold on, let her answer. Were drugs or alcohol a factor?
Oh, no, Your Honor.
Okay, go ahead.
And if anything like this were to happen again, would you call 911?
Nothing like this will happen again.
Your Honor, at this time, the state will be requesting no contact due to the fact that there have been incidences like this in the past, and the witness stated that, well, it was unclear whether she would call 911 if this did happen in the future.
I wouldn't call 911 because it won't happen.
She stated she wouldn't call 911.
Because it's not going to happen.
All right, please, Unless someone asks you a question, I know it's an emotionally charged event, but please don't respond unless you're asked a question.
And Your Honor, if I may, defense would just argue for no hostile context. She didn't say she would not call 911, she just said it wouldn't happen again. So we would just be arguing for no hostile contact at this time.
All right, I'm gonna make a no hostile contact. I'm not gonna revoke the prior bond, $2,500 bond on this case, no hostile contact. Sir, do you know what no hostile contact means? That means you can't even raise your voice. If you so much as raise your voice, you'll be in violation of your conditions of release. And you have prior bonds. That means the next judge can revoke your bond, and you won't get a bond on these cases as long as they're pending. You'll be staying here in the jail. Do you understand?
I understand, thank you.
Okay.
All right.
All right, good luck to you, sir.
No action, right, on the I don't bond, right?
Pardon?
I don't bond, right?
Yes.
425.
I hope so.
Your Honor, he was just be requesting a reduction. I don't believe he qualifies for PTR at this time.
No, he does not. He's out of bond.
What's the position of the state on reducing the bond?
Your Honor, I would leave that to your discretion.
I'll go 1,500, counsel.
Thank you, Your Honor.
$1,500 bond. Same conditions. Have a great day. You too, sir. All right, Mauricio Ramirez Pereira? Am I saying your name correct? I'm sure I'm saying it wrong. How do I say your name, sir?
That's correct.
Okay. Mr. Ramirez Pereira, I'm going to appoint the public defender standing next to you to serve as your attorney, okay? You understand?
Yes.
Okay, all right. I do find probable cause in this case. Let's hear from the victim. Ma'am, would you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, ma'am, if he gets out, do you want contact with him?
Yes.
Anything from the state?
Yes, Your Honor. Has anything like this ever happened before?
No.
And if something like this were to happen again, would you call 911?
Yes.
Do you believe that drugs or alcohol played a factor in this situation?
Objection, Your Honor, relevance.
Overruled.
You can answer.
Maybe alcohol, both.
And that's all from the state, Your Honor.
Anything from the defense? I'm inclined to order no hostile contact, counsel. Anything from the defense with
No,
the
no,
witness? Okay. It's going to be PTR, no hostile contact, and no drugs or alcohol. Sir, do you know what no hostile contact means?
No, can you please explain to me?
No hostile contact means no hostility whatsoever. Means you can't even raise your voice, okay? If you raise your voice to her, you will be in violation of your conditions of release, and your bond can be revoked, and you'll be back here in the jail. Do you understand?
Understand, sir.
Okay.
Your Honor, we would just be asking that the condition of the no alcohol or drugs would be removed. There's nothing in this affidavit indicating that he was under the influence of anything.
I'm going to keep the condition, counsel. So that means no drugs or alcohol pending this proceeding. Do you understand?
Understand.
Okay.
I'm sorry, Your Honor, and just for the record, the state is asking for no contact. I understand what you said, I just want to put that on the record.
Understood. I'm going to make it no hostile contact.
Thank you, Your Honor.
Thank you.
All right, good luck to you, sir. Harris Roosevelt.
Yes, Your Honor.
Okay, Mr. Roosevelt, I see, I'm going to appoint the public defender standing next to you to serve as your attorney, okay?
Yes, Your Honor.
I do find probable cause in this case. I see he qualifies for PTR. I'm inclined to grant the PTR with the conditions of no contact and separate residences and no return to the scene. Anything from the state?
No, Your Honor.
Anything from defense?
One moment, Your Honor. Just a one-time assist, Your Honor, to get his belongings.
One-time assist is granted.
Thank you.
So it's PTR, no contact, separate residences, no return to the scene except a one-time assist with law enforcement to retrieve your belongings, sir. Your attorney can help you arrange that. Okay,
Honor.
good luck to you, sir. Maria Torres Ruiz? Am I saying your name correctly? Ms. Torres Ruiz? Okay. All right, I do find probable cause in this case. I see she qualifies for PTR. I'm inclined to grant it. Sir, would you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
If she gets out, sir, do you want contact with her?
yes.
Okay.
What's the misunderstanding?
Anything from the state?
Yes, Your Honor. Has a situation like this ever happened before?
Never. In 27 years, never.
And if it were to happen again, would you call 911?
I would, but I wouldn't have to. It's never gonna happen.
But if it did happen?
If it did happen, I would do it, but I would never do it. I mean,
When you say I will never do it?
no, I mean, it will never happen again.
Okay.
Yeah,
Sir,
that's what I mean.
very clearly, if it happens,
If
will
it
you call
happened,
the
I will
police?
call 911, I will call the police, but I know it's not gonna happen.
Okay, anything else from the state?
Your Honor, at this time, the state will still be asking for no contact.
All right, I'm gonna make a no hostile contact. Anything from defense?
No, Your Honor.
Okay. Direct PTR, no hostile contact. Ma'am, do you know what no hostile contact means? No hostile contact means you can't even raise your voice. If you have any hostility towards him whatsoever, you'll be in violation of your conditions of release, and he may be back here, okay? Okay. Good luck to you, ma'am. Isaiah Anthony? All right, Mr. Anthony, I'm going to appoint the public defender standing next to you to serve as your attorney, okay?
Your Honor, we do have a PC argument for this as well.
Okay, let's hear it.
My client's being charged with criminal mischief of $1,000 or more. However, there is no amount listed in the affidavit as to what these damages are or how much they are.
So that's the only charge you're challenging PC on?
Also, sorry, give me 1 second.
Take your time.
Not armed with anything at the time in this affidavit.
So the affidavit says that he tried to remove the rifle, was unable to, and that he did remove the magazine, okay? Have we looked at the statute? Does possession of a magazine constitute being armed? Because I know, for instance, for purposes of some statutes, possession of ammunition is within the definition of a firearm, even though it's not our common understanding of it.
Give me 1 moment, Your Honor, I will.
That's okay. Because you're right, it just says he was unable to remove the firearm. So for instance, like for possession of a firearm by a convicted felon, like ammunition counts. So I don't know if it does in this statute, though.
Anything that specifically states that a magazine would be considered that?
I mean, is there a definition of armed? State, if you find it first, please chime in.
Absolutely, Your Honor.
I believe it's just with explosives or a dangerous weapon.
Is there a definition of dangerous weapon?
Don't see one in this statute book.
Your Honor, I guess I haven't found an exact definition of dangerous weapon, but this is what the jury instructions state. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used or threatened to be used or intended to be used in a manner likely to cause death or great bodily harm.
So 81011, 810011 has the definitions for that statute. Let's look at that. And it doesn't have anything. Can you read that language to me again, counsel?
Yes, Your Honor. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used or threatened to be used or intended to be used in a manner likely to cause death or great bodily harm.
I mean, is there anything in the affidavit showing that he used the magazine to cause any harm or intended to?
Your Honor, the state believes that a reset is required in this case.
And defense is going to object to a reset. Again,
I'm going to give him the 24 hours. It doesn't sound like sounds like you're challenging probable cause on the counts 2 and 3, but not 1 and 4, correct?
yes, Your Honor.
All right. Should I set the bond on counts 1 and 4? Or do you all just want to do that tomorrow?
I mean, the defense would ask that a bond be set and that he be ROR'd. And state decides to find or get PC, they can always file an information and accordingly.
I'm going to give him the 24 hours. But in the meantime,
Your Honor, if we'll set bond and the other ones, the state has no objection to an ROR in counts 2 and 3.
all right,
With
I'm
bond
going to ROR counts 2 and 3. I'm going to set bond on count 1 at $5,000. Count 4 at $250. Anything from the state? Anything further?
Your Honor, the
He
state,
has another case, Your Honor.
No PC on count 2 and 3.
No PC on counts 2 and 3. Possession of cannabis, is that the other case?
Yes.
All right, possession of cannabis, $500. Anything from the state?
Your Honor, the state is just asking for no weapons, firearms condition, and no drugs unless prescribed by a doctor.
Okay. Anything from defense?
Nothing from the defense, Your Honor. Thank you.
Okay, counts 2 and 3 on the 21-16167 case are no PC. Count 1, $5,000. Count 4, $250. Possession of cannabis in the next case, $500, with the conditions of no firearms and no no illegal drugs or non-prescribed medications.
Only on the possession of cannabis case with the firearms, right?
The conditions are in both cases. All the conditions are in all the conditions are in both cases. Okay, sir, good luck to you. Matthew Brady? I have here that he doesn't qualify for the public defender? According to his form?
I did not have any knowledge of that, Your Honor.
I have that he does not qualify for the public defender.
For initial appearance purposes, public defender is allowed to represent him for this
Okay,
hearing only then, at this point.
okay, all right. I'm going to appoint the public defender to serve as your attorney, sir. I see there's a prior bond.
You want to do temporary appointment?
Yes. I'm inclined to set bond at $1,000 in this case. I'm inclined not to revoke the prior bond. Anything from the state?
Nothing from the state, Your Honor.
Okay. Anything from
Your Honor.
defense?
I apologize, yes. We just for clarification, was the public defender's office only appointed during initial appearances, so we're not provisionally appointed on the case?
Correct, just for the initial appearance.
Thank you, Your Honor. Thank you, Your Honor.
Okay. Sir, All right, bring it. So you understand, I'm not revoking your prior bond, okay? If I were to revoke that prior bond, you'd be stuck in here until the conclusion of that charge. If you get brought in again, the next judge, you're entitled to a bond on your new charges. If a bond is revoked, you're not going to be entitled to a bond, and you're going to be in here pending the conclusion of that case. Do you understand? Okay, don't be brought in again. All right.
And Your Honor, Mr. Jones is next, and he signed the form to waive his readings. And there's also a small argument for this case as well.
Yeah, I looked at this. I don't think there's probable cause here. The affidavit says the person tried to force him into a car. That's a forcible felony, and you're entitled to, in the state of Florida, you're entitled to engage in self-defense when that happens.
Your Honor, the state is asking for a 24-hour reset in this case. Like I've stated before, the arrest happened less than 24 hours ago. Well, now at this point, 24 hours ago. The state has 48 hours to bring forth a probable cause, and the state is asking for the additional 24 hours at this point.
And defense is objecting to this. The affidavit's quite clear. The argument that defense was going to make was that it was a self-defense issue here. We would be asking at least for my client's release on ROR, and state can file the charges accordingly.
Your Honor, the state is entitled to 48 hours.
I'm going to give the 48 hours. I find no probable cause in the affidavit as it sits. I'll give the state 48 hours. Yes, the affidavit establishes lawful self-defense.
So he's to remain.
He's going to get 48 hours. They're going to get 48 hours, but the affidavit as it sits does not have probable cause.
24 hours.
24 hours. Well, 48 total.
Thank you.
But 24 more.
So you want to do 24, not till tomorrow?
He'll be back tomorrow.
Okay.
He'll be back tomorrow. So 24 from now.
Thank you, Your Honor.
All right, thank you, sir. You have a nice afternoon. All right. This affidavit didn't contain anything about the burglary or criminal mischief that I saw. Was there another piece to this?
Your Honor, the state is asking for a 24-hour reset in this case.
Even if I set bond on the other charges, you still want a 24-hour reset?
Yes, Your Honor.
The defense is objecting to these resets at this point. I mean, the affidavits are, my client's here for court. He's ready to go for his court hearing. I'm actually in the process of looking up a case law on this specific topic. I believe they have 48 hours to establish their probable cause. However, we're already at initial appearances, and if I can have a
But
moment.
is there something in the statute that says if we have an initial appearance, they don't get their 48 hours?
No,
I
Your Honor.
believe there is a case law out there. I just need a moment to look that if they're already brought to their hearing, this is their hearing time frame. It's in the court's discretion to allow 24 hours for them to bring things in. However,
So you agree it's up to me?
it's in the court's discretion, yes, Your Honor.
All right. I'm going to go ahead and set bond on the other ones in this one. He's going to get bond on the other charges. I will ROR counts 1 and count 3 for lack of probable cause. Count 2, bond is set at $500. Count 4, $500. Count 5, $500.
I apologize, Judge. So count
time.
1, it's $500?
I think count 1 was the burglary. That's ROR'd.
Okay, thank you.
Count 2 is 500. Count 3 is 500. Count 4 is ROR'd for lack of PC. And count 5 is 500.
And I believe defense, we had an argument for count 2 on the burglary tool.
Hold on, can I see that packet back for this case? I'm sorry, 1 and 3 are hard. Let me hear from her. Go ahead, counsel.
Okay, so defense is arguing this case that the burglary tool, definition of burglary tool here. The intentions of the tool that was used, its natural intention is it's a safety tool. It's not a tool that's used for burglary. It's actually used to open windows when people are in need of help. So we'd be arguing that charge. There's nothing in the affidavit indicating that there was any resisting happening in this case. And I believe we're arguing the amount of the damages. I can have 1 second. Yeah, I don't believe that state has proven the amount of criminal mischief damages here. There isn't even a number identified in this affidavit as to how much.
State, any response as to the probable
Yes, Your
cause?
Honor. I understood that you were RORing on the criminal mischief.
Yes.
Okay, so in terms.
I think she's made a probable cause as to counts 2 and as to counts 4 now.
Okay, so as to counts 4, the officer did have visual on 3 suspects, and then he did engage in a foot pursuit with them. Additionally,
But is Mr. Jones one of the 2 that left?
he said that he was able, that both the subjects were detained, and then he was able to identify one of the detained subjects. So I attribute that to being that.
I think that's right. All right, I'm gonna find probable cause. I'm gonna ROR counts 1, 2, and 3.
Your Honor, may I respond to count 2?
Go ahead, but a window punch, that's not inherently a burglary tool.
So, Your Honor, in Keys v. State, the second DCA described, it says, in effect, when a person is accused of possessing burglary tools, the state must prove beyond every reasonable doubt, which, as we know, is not the standard here, not merely that the accused intended to commit a burglary or trespass while those tools were in his possession, but that the accused actually intended to use those tools to perpetuate a crime. In this situation, there were cars with windows broken, which meant, the way that I interpret it, is that there's probable cause that this tool was used to break into those cars. The windows were broken on the cars. Therefore, I believe that there is probable cause that this tool was a burglary tool.
Where does it say in the affidavit that windows were broken on other cars?
It said that, pursuit. At the bottom, the paragraph before the final paragraph, both victims completed sworn written statements advising they wanted to press charges for the broken windows and burglary of the vehicles.
I'm gonna find no probable cause on count 2. Count 4, I find probable cause as well as count 5. So counts 1, 2, and 3 are ROR'd for no PC, no probable cause. Counts 4 and 5 are $500 each.
Thank you, Your Honor.
Okay. Good luck to you, sir. All right, Daniel Maldonado? Oh, okay, we'll reset that for tomorrow. Daniel Maldonado's a reset. Douglas Scotland? Okay, he didn't show up. It's a failure to appear. I'm inclined to give no bond. Anything from the state?
Your Honor, the state would ask for no bond.
Counsel?
We would be asking for a bond. Give me 1 second, Your Honor. Defense is unaware of his history at this time because at initial appearance was not provided that, but if he doesn't have any failure to appear, we would just be asking for a bond in this case.
I'm going to deny bond.
I believe there's some discrepancy as to when the case was filed and or when his next court date was to be.
What's the nature of the discrepancy?
I believe he stated that he spoke to somebody and wasn't sure if these charges were even filed on. And so he didn't think he even had a case.
All right, sir, I'm going to give you a bond. If you do not show up to your next appearance, it is very unlikely the next judge is going to give you a bond. Do you understand?
So now, because I went down to the public defender's office.
I'm sorry?
I went to the public defender's office for the second case, and my one lawyer told me to go up to her and ask her to give me the case, if I had a case number, but she's stuffing envelopes.
All right, it's going to be on you to work with your attorney to figure that out. You have a responsibility to show up to court. And I'm telling you, if you don't show up the next time, it's very unlikely the next judge is going to give you a bond. Do you understand? All right, bond set at $2,500.
Your Honor, just for the record, I heard what you said. Just for the record, the state would ask for no bond because the judge who issued the warrant issued a no bond warrant.
Let me see. Sorry. Where's the warrant out of?
Orange County, Your Honor.
Who signed the warrant?
I'm sorry, Your Honor, I don't have that information. I just see here that it was issued no bond. Other times, other warrants are given a bond, and therefore, I interpret that to be that there was no bond on this warrant.
I'm going to stick with the $2,500 bond. Sir, if you don't show up next time, it is very unlikely you're going to get a bond, you understand? Okay.
Thank you, Your Honor.
Willie Smith? All right, Mr. Smith, I'm going to appoint the public defender as your attorney to represent you. I do find probable cause in this case. I'm inclined to set the bond on count 1 at $1,000, count 2 at $100, count 3 at $250, with the condition of no drugs or alcohol. Anything from the state?
Nothing from the state, Your Honor.
Anything from defense?
One moment, Your Honor. Your Honor, what was the bond set at? I apologize.
$1,000 on count 1, $100 on count 2, $250 on count 3. With the condition of no drugs or alcohol. Counsel?
My client would just be asking for a bond reduction as he can only afford a $200 bond at this time.
You're saying he can afford 200 as a 10% of the bond, or as 200 total, meaning basically $20?
To 10% of the bond.
So 200 being the 10%? Or,
Yes, Your Honor.
okay, well, his bond's gonna be set at $13.50, so that's $135,
Okay, I can afford that.
right?
No, Your Honor, in each count, so 1,000, 1,000, and 250, it's gonna be 10% of each one.
Yeah, so 1,000 is 100, $100 will be $10, and 250 is gonna be 25.
No, it would be 100 for each count.
The second count is 100.
The second count is $100, so count one is $1,000, count two is $100, count three is 250.
Your Honor, and the bondsman's, from my understanding, is always gonna be $100 each count as the lowest. They won't even take $50. So like, on the 50, they won't do that. It always rounds up to 100 per charge.
What's the position of the state?
Your Honor, I would leave the bond amount up to you.
All right, I'm gonna set count one at $1,000. I'm gonna ROR count two. And I'm gonna set count three at $350. With the condition of no drugs or alcohol. After I have next, you're done, sir, thank you. I have Demetrius Brandon next.
Not on my docket.
Do you have a booking number for them, Your Honor?
21 CT 8342.
It would be on the affidavit's jail number.
FHP
No.
210 29782.
They bonded.
Okay. Is this Miss Pope? All right, after Miss Pope, we're going to take a 5-minute break, so you don't need to bring in the next inmate yet. All right, Ms. Pope, I'm going to appoint the public defender to serve as your attorney. I do find probable cause in this case. Does the state have a suggestion as to the bond?
Your Honor, it does say on my sheet that the bond is set at $500.
And defense will just be asking for an ROR. I believe it's a no valid driver's license charge.
It's a failure to appear for it, though. I'm going to set the bond at $500. Ma'am, your bond is set at $500, okay? All right. Let's take a 5-minute break.
Thank you, Your Honor.
Okay. I think I had it on the, to where everybody can hear me, but Mr. Antoine, I'm going to appoint the public defender to serve as your attorney. I do find probable cause in this case. I'm inclined to set bond at $500. Anything from the state?
Nothing from the state, Your Honor.
Anything from defense?
One moment, Your Honor. Does he qualify for a direct PTR?
No, no, he does not.
And defense would just be asking because my client doesn't have the funds, if this could be an ROR, it is a resisting without violence charge and simple misdemeanor.
Any objection from the state?
Your Honor, the state would leave it to the court's discretion at this time.
All right, I'll ROR you, Mr. Williams, or Mr. Antoine. If you get, that can be revoked by the next judge, so if you get picked up, that could be revoked, okay? Make sure you don't get picked up again, all right?
Yes, sir.
All right, sir. Good luck to you. All right, James Bridges.
Jamie Bridges.
Oh, Jamie Bridges, I'm sorry. All right, Ms. Bridges, I'm going to appoint the public defender standing next to you to serve as your attorney, okay? I do find probable cause in this case. I'm inclined to set the bond at $500. Anything from the state?
Your Honor, the state has no objection to an ROR in this case.
Okay, then I'll ROR it. I assume
Yes,
that's
sir.
okay with defense counsel?
Yes, Your Honor.
All right, ma'am. You're going to get out today. You have a wonderful day, okay?
I'm sorry.
Oh, hold on.
May the state just add, no contact with Mr. Willie Smith, who is,
Co-defendant?
yeah.
I'm going to grant that. No contact with co-defendant Willie Smith. Do you understand, Ms. Bridges? Okay. Okay. Have a good day, ma'am. Alfonso Harvey? Or Alfonso, yeah, Alfonso Harvey. All right, Mr. Harvey. I'm going to appoint the public defender to serve as your attorney. He was picked up on a prior warrant. I'm sorry. I do find probable cause in this case. I'm inclined to set bond at $500 for each of the three charges for a total of $1,500. Anything from the state?
Nothing from the state, Your Honor.
Anything from defense?
Your Honor, I'm just reviewing the affidavit as the charges are 3 of the same.
I believe they're alleging 3 different acts of resistance. If you go through it, there were several acts he took that could each be characterized as resisting arrest.
Defense needs to look up the statute, but from what I would recall, it would be from one incident. So if he resisted in one incident,
Show me the statutory language and I'll take a look at it.
give me one moment, Your Honor.
But I do see 3 acts of resistance here, but if the statute limits it to an incident, that's something I should take into account. No, don't speak unless your attorney says you can, sir. I mean, you have a right to speak if you want, but I would strongly suggest that you talk to your attorney first and do what she says.
And Your Honor, he doesn't qualify for pretrial release?
No.
I do not have
He
qualifications for
does not.
trial release.
And while I kind of look up the statute, my client did indicate that his affordability at this time is only $100.
What's the position of the state on this case?
Your Honor, I would just ask that bond be set in 1 charge, and I have no objection to ROR in 2, but I do believe that a bond should be, it is my opinion, that a bond should be set in this case.
All right, I'm going to set a bond of $1,000 on count 1, and I'm going to ROR counts 2 and 3.
Thank you, Your Honor.
All right, sir. Good luck to you, sir. All right, Shadrick Wright, right? Yes, sir. All right, so you're next. Let the prior gentleman finish up. All right, Mr. Wright, I'm going to appoint the public defender. I'm sorry. Yeah, Mr. Wright, I'm going to appoint the public defender to serve as your attorney. I do find probable cause in this case. There's a prior bond. I'm inclined to set bond in this case at $500 with a no contact. I am not inclined to revoke the prior bond. Anything from the state?
Your Honor, the state would just be asking for no contact with the code. Oh, I'm sorry.
What?
Is that what you meant when you said no?
Yeah, no contact with the victim.
Oh, also the co-defendants, Your Honor.
Okay. Anything from the defense?
Your Honor, this is the affidavit I did not receive.
Do you want to take a look at mine?
Yes, please, if I may approach.
Yeah, go ahead. Yes. State, you have the affidavit, correct?
Yes, Your Honor.
Like I said, I'm inclined to set bond at $500 with no contact to the victim or co-defendants. I'm not inclined to revoke the prior bond. It sounds like that was okay with the state. Defense?
Nothing further, that's okay with the defense, thank you.
Okay, all right. Bond is set at 500, no contact with defense, co-defendants, or...
That's it.
Sir, you can say something, but I strongly suggest you speak with your attorney first. Have you done
I
that?
had to say thank you, that's it.
Oh, okay. Sir, you have a wonderful afternoon, okay?
You too, sir.
All right.
Okay, no problem.
Okay, Christopher Campbell? All right, this was an out-of-county warrant that came in at no bond. I'm inclined to leave it that way, so I'm going to appoint the public defender to serve as your attorney. Anything from the state?
Nothing from the state, Your Honor.
Anything from defense?
One moment, Your Honor. Your Honor, my client is inquiring if he can have a bond in this case. I believe this charge is out of Polk County. He does have a document here indicating there was a bond of $5,000 on this case.
It's on one charge, there's two charges.
The only affidavit that I have just states that there's a warrant.
All right, I'm not going to change the Polk County warrant. It's going to be no bond.
Thank you, Your Honor.
So my clerk is telling me there's a mistake and that there's two issues with Mr. Campbell?
There's two charges. One case, the two charges.
Is the out-of-county warrant on both of them?
Yeah, it's all out of Polk County. It's just a written threat to kill and then an aggravated stalking DV. Two charges.
Okay, no bond.
Oh, the one did have a bond of 5,000.
Oh,
One
okay.
had a
All
bond
right,
of
that's not in my paperwork.
9.
That'll remain at 5,000 then.
Okay.
Thank you, Your Honor.
Yeah, they messed up.
Okay, that's okay. Well, thank you for showing me that. All right, Horace Evans? Yeah, okay, that makes sense. Ricky Irizarry?
Yes, sir.
Do you have a family case pending, sir, in Orange County?
Case?
A family law case? Okay. This is an out-of-county warrant. It came in on no bond. I'm going to appoint the public defender to serve as your attorney, sir. I'm inclined to leave the out-of-county warrant at no bond. Anything from the state?
Your Honor, the state would agree with the no bond.
Anything from defense?
Your Honor, this is a out-of-county warrant for failure to appear. Defense is just going to ask for a bond in this case.
I'm not going to change the out-of-county warrant. No bond, sir.
Thank you, Your Honor.
All right, next I have Raymond Belsner. Mr. Belsner, I'm going to appoint the public defender to serve as your attorney, okay?
Yes.
I do find probable cause in this case. What's the state's request as to a bond?
Your Honor, Whatever this court feels is appropriate.
Okay, he's here in a violation of probation.
May we hear the history from PTR?
Would you like the history, Your Honor?
Yes.
He has 6 felony convictions, 24 misdemeanor convictions, 1 failure to appear, 3 DOC stays, convictions for multiple trespass, battery, open container, soliciting without a permit, attempted burglary of a dwelling, criminal mischief, resisting officer without violence, twice possession of controlled substance, burglary of a structure multiple times, 2 possession of drug paraphernalia, 2 possession of cannabis less than 20 grams, 2 duelists as a habitual offender, battery, domestic violence, shoplifting.
All right, I believe in this case, he's not entitled to a bond, is that right?
I believe you're correct, Your Honor.
I'm inclined to no bond this one. Anything from defense?
Your Honor, I'm just looking at the affidavit to see what they're alleging his violations are. It looks like there's only 1 alleged violation, and it just looks like it's a change of residence. So defense would just be asking it as a minor violation, and if a bond could be set in this case.
I'm no bonding this one.
Thank you, Your Honor.
Okay, Dennis Hoover?
Hold on.
Okay, Mr. Hoover? Oh, sorry, take your time. Good afternoon, Mr. Hoover.
Morning.
I'm going to appoint the public defender standing next to you to serve as your attorney, okay?
Yes, sir.
All right, I find probable cause. I'm inclined to ROR it. What's the position of the state?
Your Honor, the state has an offer to resolve this case.
Okay, go ahead.
Withhold credit time served, court costs.
If I can have a moment to
Yeah,
really.
take as much time as you need.
into the plea today.
Okay,
He would enter a plea of no contest.
all right. Mr. Hoover, would you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Do you understand the plea you're making, sir?
Yes, sir.
Have you had a chance to speak it over with your attorney?
Yes, sir.
Do you wish to talk to your attorney about it any further?
No, sir.
Okay. Did you fill out this plea form?
Sir.
Did you read it and understand it?
Yes, sir.
Okay. Court will accept the plea. The plea was withhold adjudication, credit time served. How many days have been served?
2.
2. Credit time served of 2 days. Court costs reduced to a civil judgment. You have 30 days to appeal, sir.
You too. Thank you.
All right, we are getting close to the end. Or is that everything, actually?
That should be all, Your Honor.
Okay.
I believe that's everything, Your Honor. I just did want to bring up the one reset that was a misdemeanor. I just wanted to readdress it again to see if the court would be inclined to release him ROR while state
What's
looks
the name
into
of the
probable
defendant?
cause. I believe it's Thompson. Just running back through this docket again, I apologize.
That's okay. Just let me know the name whenever you have it.
And Your Honor, if the state may rebut briefly.
Oh, I'm not gonna do anything without hearing from you, State.
Okay.
I'm waiting for her to find the name of the defendant.
I believe, Your Honor, on page 2, number 13.
What's the name of the
Edwin
defendant?
Maldonado Carabello?
Can you hand me Maldonado Carabello? Maldonado, what's the first
Edwin?
name?
Edwin?
Edwin Maldonado Carabello?
He was a misdemeanor DV. Sorry.
This is the one with the cell phone?
Yes, Your Honor, I believe so.
All right, what's the response from the state?
Your Honor, the state would just be asking for a reset. As I stated earlier, the Florida Rules of Criminal Procedure 3.133.
No, I know what the rules say. It's in my discretion, correct? So it's a discretionary matter. What's your argument as to
Well, Your
how I should
Honor,
exercise the discretion? I know I can reset it. What's your argument as to why I should?
because, Your Honor, the police affidavit says that he became aggressive and began yelling at the victim. We don't